appoint 34 judges to the exclusion of 4 High Court judges and 2 magistrates. The Kenya Magistrates and Judges Association gave a very strong statement that act is unconstitutional and is not based on any form of law. I want to reiterate that the President's assertion referring back the names to JSC has an implication, one, as an institution of disciplinary processes. The judges, the 4 judges, have under Article 168 of the Constitution a process of removal from office. The 2 magistrates do not have security of tenure like the judges. Most likely, they are going to be interdicted and be dismissed. The questions my clients are raising is that does the JSC have the power to revisit the names that they already dealt with? They cleared these people. They cleared the judges to be as clean as cotton. Under which law does the President have to countermand or send back the names? Yes, in the legislature, once Parliament passes the law, if the President is aggrieved with that law, he sends it back to Parliament, and unless Parliament raises 2/3 of the MPs, that law still remains as it is. Under the JSC Act and under the Constitution, that provision is not available. So, we are consulting with the Kenya Magistrates and Judges Association with a view of knowing what legal action will be taken to defend the members of the Kenya Judges and Magistrates Association. But we reiterate that the statement issued by KMJA is factual, and we demand that the President cannot cherry pick and cannot decide who to appoint and who not to appoint. In the proceedings, if ever it will happen, is the President now going to give the complaints against the 6 members? My clients, none of them has been given the reasons as to why the President decided not to appoint them. JSC never presented the issues to the members of KMJA to them to respond. Is it now ripe that they be given what the specific allegations are? Will the NSIS, the one that has produced that evidence, swear an affidavit to provide so that they are cross-examined over the veracity of that averment that has made them lose the position of being a judge? So the questions that we are pushing across is that let all the judges be appointed. We know very well the jurisprudence of appointment of judges. President retired Kibaki refused to appoint judges until 2014, when President Uhuru Kenyatta, under a lot of pressure, appointed the remaining judges. We are demanding, as lawyers, as practitioners of the law, and as KMJ, that the members' voice be added to the Kenyans, that we demand the President to correct that anomaly and push the names to the Kenya Gazette and they be appointed. We shall be observing, as KMJA, my members are observing the very many cases that have been filed in court challenging the President's decision. Once KMJA sits and makes an executive decision, I will brief the members of the Fourth Estate and the country the directions KMJ is taking. But for now, still we reiterate that the president had no locus, had no reason, none in law, nor constitutionally, to deny the appointment of those judges. Some of those magistrates have done tremendous work. The judges have done tremendous work. Let the president heed this call and appoint the judges. We hope within today or tomorrow the president will do that. Thank you. Yes. And judges and magistrates, every complainant must come and be cross-examined. That is the law. President Uhuru Kenyatta and William Ruto were in the ICC under Article 68 of the Rome Statute. The ICC wanted to bring evidence of people who are not ready to come and testify. That matter went to the Chamber of Appeal. The Chamber of Appeal said it cannot rely on evidence if somebody does not come to testify. Is NIS coming to give evidence? Can they appear? Because the judges believe in the rule of natural justice. If there is a complaint, place it before. Let the accuser give evidence. But if it is somebody saying, we have information, we have intelligence information, that can't be the basis to deny somebody a job, to deny somebody a career progression. Today, my members, my clients, some of them, the 6, have no face. How do they proceed in court when everybody is saying the president has raised doubt on their capacity and on their integrity? Those are the issues.
Council, will you be also requiring the return?
Because I have no instructions from my clients. The effect of the rejection does not mean, because the appointing authority, the employer is JSC. The judges will continue discharging their duties and their mandate pursuant to the oath they took. The only way to remove a judge is provided for in Article 168. A petition is filed to JSC. JSC looks at the evidence. If it meets the threshold, it recommends to the president to appoint a tribunal. Once the tribunal finds that there is sufficient evidence, it recommends to the president for removal of that judge. That is the specified way. For the 2 magistrates, it will be either 1, an interdiction will ensue, then a show cause letter will be done. They appear before the JSC disciplinary committee. If they are satisfied that the allegations against the magistrate warrant sacking, then that magistrate will be sacked. That is what we are saying. Especially the 2 magistrates are totally exposed, because anybody acting arbitrarily will interdict them today. And the question that will be, if JSC interdicts them today, it is JSC that approved them and cleared them and was satisfied that they were right people to be promoted to be judges. What will be the effect, net effect, to the JSC?
Names of the 2 magistrates?
Yago, Chief Magistrate Mombasa, and the other one is the Registrar of the High Court, Omange. Law, it is not about what Maraga said. The law does not give the president the mandate or the power to select who to select. It's not about the backlog. It's about the constitutional provision that the president in this matter is just a conveyor belt, a ceremonial. He gazettes and presides over the function of taking the oath of office.
Thank you.
Thank you.